This week on the Communicators, reaction to an effort by the Federal Communications Commission to reclassify certain broadband services. Our guest is Republican Commissioner Robert McDowell.
Well, this week, the Federal Communications Commission has voted to begin the process of reclassifying broadband services. Here is the chairman of the FCC talking about his view on this issue.
I'm pleased also that this process has produced healthy dialogue inside the Commission, among the Commission staff and among those of us here on the bench. There are a number of different views as we begin tackling these issues. I believe firmly and deeply in the benefits of a free marketplace of ideas, of robust discussion and public debate, and its potential to produce the best answers to hard questions as long as all keep open minds. I ask only this of all participants in the discussion. Let's not pretend that the problems with the state of broadband in America don't exist. Let's not pretend that the risk of excessive regulation is not real, or at the other extreme, that the absence of basic protections for competition and consumers is acceptable. Instead, let's put rhetoric and posturing aside and work together to solve the problem created by the court case so that we can rise together to the major 21st century challenges of achieving U.S. world leadership in broadband and innovation, fostering sustainable economic growth and job creation, and bringing the benefits of broadband to all Americans. With that, I will ask for a vote. All those in favor say aye.
Aye.
All those opposed say nay.
Nay.
The ayes have it, and the request for editorial privileges is granted.
Robert McDowell, the leading Republican commissioner on the FCC. We heard a very loud nay from you on that. What exactly did you vote on, and why did you vote no?
This was a notice of inquiry. It initiates a fact-gathering and comment process for a number of ideas that are teed up in this notice of inquiry. Shorthand, we call it the FCC an NOI, so I might slip and refer to it as that. But this is actually the review of an issue that has been looked at many times over the decades. And we can go more in depth on that, but this is not anything new. These ideas have actually been examined thoroughly over the years and discarded. And I spent a large portion of my time yesterday's meeting at the FCC, talking about how the Clinton-Gordon administration actually looked at this in the 1990s very carefully and discarded the common carrier regulation, or regulating broadband internet access as a monopoly phone service, under what we call Title II of the Communications Act of 1934.
Do you consider broadband a common carrier?
No. It is very different. So when you look at the Communications Act of 1934, it was obviously written in 1934 for analog, circuit-switched, voice, monopoly telephone service of the day. And that's very different from the complex, computer-based, interactive IP Internet Protocol networks of today. I think what the Commission is trying to do now is essentially to legislate, and it is really a question for Congress to address these issues, that we don't have the statutory authority to do what we're doing.
So if you are against broadband being re-regulated as a Title II service, specifically why are you against that?
First of all, I would not use the word re-regulate. There's a myth out there that somehow there was a status quo of the past where it was regulated as a monopoly phone service. It never has been. This spans 4 decades of the FCC, where we've always treated information services, these interactive computer services, differently from monopoly voice services of the old Ma Bell monopoly. So that is a big distinction. Also, broadband has really flourished in the absence of such regulation. So let's go back. Let's look to see if there is any evidence of systemic market failure. And the government has actually examined this question many times over the past several years, recently actually. The Federal Trade Commission looked at it in 2007, issued a 5-0 unanimous bipartisan vote that said there is no evidence of systemic market failure, and in fact cautioned against rules such as these being proposed today by the chairman and the majority. The FCC, the Federal Communications Commission, my agency when I was there earlier, was also looking at this issue, cast its nets widely to try to harvest some evidence of market failure. Couldn't find any. The Department of Justice this January, so the Obama Department of Justice, their antitrust division, filed comments with the FCC saying this is not a natural monopoly, and actually the Department of Justice was very optimistic about new competition in the broadband market. And that's with an emphasis on what's happening in the wireless space. So wireless technologies are really where consumers are migrating to a heavy degree. So we see wireless broadband as the fastest growing segment of the broadband market. And we have about 76% of the country now has a choice of 3 wireless broadband providers. That number is growing tremendously each day. It is very hopeful and very optimistic. I also hope that the Commission would continue with the efforts that we codified in November of 2008, and that is to use something called the television white spaces, the unused TV channels in a market for unlicensed use of very good spectrum where signals travel a long distance and can penetrate buildings and are perfect for wireless broadband. And the importance of unlicensed use is that that technology is more apt to spread quickly and to be adopted by consumers quickly, just like with Wi-Fi. So if you think of white spaces as Wi-Fi on steroids because the signals travel farther and can carry more information. So if you have unlicensed use and more competition in that last mile, then if you have some knucklehead out there who wants to be anti-competitive, to frustrate their own consumers' demand, which doesn't make for a great business model, but if they want to have a knuckleheaded move like that, then that is to the advantage of a competitor, either an unlicensed competitor using the white spaces or another wireline competitor, cable or fiber or whatever the case might be. But if you have enough competition in the last mile, all of these concerns regarding manipulation of content in an anti-competitive way disappear. We don't have a Federal Clothing Commission, the other FCC, because there's competition in clothing. So if we have enough competition in the last mile, you don't need these kinds of rules.
Robert McDowell is our guest this week on the Communicators, the leading Republican on the FCC, and also joining us is Tony Rahm, reporter with Politico. Mr. Rahm.
Great, thank you so much for having me. Commissioner, thanks so much for joining. I guess the big operative question here is, why is the FCC moving towards the third way or towards some new framework for broadband? You hear Chairman Julius Genachowski talking about it as the only way to begin expanding broadband and to beef up the Universal Service Fund, among other important components when it comes to expanding high-speed internet access. But one of the things that you had said in your opening statement yesterday was that we don't need to go through this mechanism in order to improve USF or to embark on these other reforms. How would you go about doing those things, though?
Absolutely. So his concern, just so the listeners understand what you're saying, because
Sure.
you're speaking from the AP section of the class.
Exactly.
So let me make sure your aunt who might be watching or your grandparents or something understand what we're talking about. There was a court decision that came out in April, the day after Duke won the National Basketball Championship. I remember this very vividly. But anyway, so it said that basically the Commission could not use what we call Title I. We were talking about Title II earlier as the phone regulation. Title I is called our ancillary jurisdiction. So you can do certain things, you can have certain regulations come out of the FCC under Title I, but only if it's tethered to some sort of direct congressional mandate that's very specific somewhere else in the Communications Act. And that's been the long-standing rule of law by the courts for quite some time now. So it didn't come as any surprise, because this is a case involving Comcast versus the FCC, but also involving BitTorrent. It's a case where I dissented because I didn't think we had the authority to do what we were doing. So all the court said there is the Commission, the FCC, did not have the authority to issue network management rules, internet network management rules, because it couldn't point to any place in the Act, as drafted by Congress, that gave them the authority to do that. And so it was very specific and very narrow. That same court, the U.S. Court of Appeals for the D.C. Circuit, has also upheld our attempts to basically tax voice-over internet providers to help them, help us rather, get more money for the Universal Service Fund that you referred to. It is also, and that was under not a direct congressional mandate, except as codified in that section of the statute that says we can do certain things to help the Universal Service Fund. Same thing with voice-over internet providers and enhanced 911, the mandates there. Voice-over internet has not been classified as a typical phone service for Title II purposes. it remains sort of without that classification at this time. So the point I'm trying to make is a long-winded way of saying I think we still have authority to reform universal service substantially based on the explicit authority we're given under what's called Section 254, not to sound too much like a lawyer, of the Act that gives us the authority to modify the Universal Service Fund, which is an almost $9 billion a year subsidy, one of the largest subsidy funds administered by the federal government. But even if it didn't, there's a workaround. The workaround is if you're a traditional phone company that's receiving subsidies, let's say to provide service in a rural area for traditional voice services, we can tie that subsidy to your performance in the broadband market. So we can, and that's a concept that 4 commissioners in November of 2008, 2 Republicans, 2 Democrats, we all agreed to in principle of this workaround concept. That clearly would survive appeal. I think the courts would also look favorably on us trying to support broadband, let's say, with this subsidy directly through our authority in the Act.
Sure, and that's the operative next question. Do you think a push to revise the USF or to look towards other ways to expand broadband could survive a court challenge of that nature? I mean, because there are supporters on the other side who say that it couldn't unless you push towards reclassification.
Absolutely. I think the argument that somehow this Comcast case obliterates our ability to do anything in the broadband space is a complete overreach. It is far more broad than what really happened with the court. So at a minimum, you have this workaround idea that I just talked about for universal service. And it's also been tied to the National Broadband Plan that the Commission submitted to Congress, or the Chairman submitted to Congress on March 16th. And the 2 big components there were to revise universal service to help support broadband, but also to bring more spectrum, more of the airwaves to the market, find more ways to bring that to market so we can have more wireless broadband, more competition. And there's no way you can argue that that Comcast decision affects our ability to do that.
Commissioner McDowell, your Democratic colleagues on the FCC have stressed very strongly the importance of this case in their actions. I mean, Chairman Janikowski yesterday in his opening remarks said that because of the Comcast case, it created uncertainty in an area that had been widely regarded as settled. He went on to say because of the court case, the FCC has an obligation to move forward with an open, constructive public comment process to ask hard questions. Commissioner Clyburn has also made very strong comments about the Comcast case, but you don't feel the same?
I disagree very strongly. I think what's created uncertainty is actually discussion of trying to regulate the internet under common carrier rules, the old phone monopoly rules. It was actually very settled for years, and this is something that really gained a lot of traction in the Clinton administration, and they teed up the process actually for the classification of originally cable broadband, cable modem, in 2002. So it went from the Clinton administration into the Bush administration. To classify that as this less regulated information service, and it went from there. And in the course of that, broadband has proliferated wonderfully. We see great innovation and investment at what we call the edge of the internet. That's devices, computers, wireless devices, and applications, the software, right? That is exploding. That is unfettered by regulation as it should be, and is exploding beautifully. But we also want to see innovation at the core within the networks of the internet. And the edge and the core are kind of converging from a consumer's perspective. They don't care really how these services are delivered to them, so long as they have competition and innovation and lower prices that they can enjoy. And that's what's happening now. But unfortunately, what's been proposed creates an asymmetry in the market. It places the thumb of government on the core of the internet and says we can have unfettered innovation at the edge, but in the core, the government's going to have a mother may I approach. And this, I think, history has shown, will stifle innovation and deployment. One example I can give of that. The first broadband technology to market was cable broadband, cable modem, which was unregulated. DSL, which was offered by phone companies, had to play catch up because it was regulated. So once that became less regulated, we saw proliferation, build out, and adoption, in other words, really explode wonderfully. Now, same with wireless. Wireless has been largely unregulated. I'm very concerned that the Commission may be poised to start heavily regulating the wireless industry.
Have you seen signs of that?
Well, certainly this NOI, for instance. So are we going to say that now all wireless broadband is common carriage, or all wireless will be treated under Title II? Congress adopted portions of Title II in Title III, the little legal lesson we're getting today. Title III is for wireless. That was, I think, in 1993, if my dates are correct, to adopt some of those provisions for interconnection purposes between wireless carriers or wireless carriers and wireline carriers. But we can't do that. We cannot legislate. Only Congress can legislate. Congress was very narrow and specific in that. So yeah, I'm very concerned about this item, regulating the wireless industry, and some other overtures or prelude to regulation that we've seen recently.
Would you say that broadband is the new national medium, as Reed Hundt, the former chairman of the FCC, has said?
Well, it's becoming so, absolutely. When you have 70+% of America actually subscribing, you have 95% deployment of broadband facilities, and you have only 7 million out of 114 million households without access to broadband.
So how do you reconcile that with it not being a common carrier, or needing more regulation?
Well, again, competition is the ultimate antidote to regulation. So where you have competition, you don't need regulation. Back to the Federal Clothing Commission that does not exist, right? So the fact that it's a national medium could be terrific, but when there's competition there, you don't need that regulation.
Tony Rom.
Sure. One of the biggest flashpoints in all this is what Congress's role might be. I mean, we hear a lot about maybe we should let Congress take the lead on this issue, and that's actually one of the things that you had brought up yesterday, this thimble statement that the FCC is not Congress. But is there a fear among you and other commissioners that maybe Congress won't get to that issue as quickly as it should, or that any kind of update to the 1996 Communications Act might just take too long? And what effects might that have on the FCC and how it moves ahead on issues like broadband?
Well, let me challenge the premise of your question.
Sure.
What's the problem we're trying to fix?
Anything from expanding broadband. I mean, as you had just said, broadband is not as big of an issue as some on the FCC have said. But the question is, if Congress does need to update that Communications Act to make this authority clearer, to deal with any of these legal issues that might arise, whether they, essential or not, is that something that you see Congress being able to tackle in the next couple months or next couple years?
Well, I'll get to that in a minute, but I sort of challenge the premise that we need authority to do what?
Sure. I mean, but just to clarify some of these legal disputes. I mean, the back and forth between some who say that you need any authority and those who don't, just to make sure there's explicit explanation of this is what the FCC can do in this area and this is what it probably shouldn't be doing.
So to answer your question directly, it takes a long time sometimes for legislation,
Sure.
right? The legislative process can be ugly sausage making, I think Bismarck said. So that can take a while, or it could be quick. It's a matter of what the priorities of Congress are. But I have to ask, what is the problem we're trying to solve? And time again, the government has asked that question, and there is no evidence of systemic market failure. So bring that to me. I mean, one upside perhaps to this notice of inquiry that we just that the majority voted out yesterday is that it'll give folks yet another chance to an opportunity to bring us evidence of systemic market failure, and also to flesh out some of these legal arguments as to what the FCC has authority to do. I think it's very clear. The only uncertainty we've had recently is that caused by discussion of Title II regulation of the internet.
So I guess the retooled question then is, should Congress move ahead with some kind of update to the 1996 Communications Act, and what should it look like?
So that's a much better question. So I don't mean to grade your questions, but so certainly the 1996 Act was the last major overhaul of legislation, right? And we still see these silos. So we've been talking about Title I, Title II, Title III, which is probably very confusing to the folks watching back home. But from a consumer's perspective, the difference between a broadcaster and cable television, my kids can't understand that difference, or even now broadcaster cable television and the internet. ComScore is reporting billions, 35 billion video downloads each month in the U.S., growing at double-digit rates every year. So as these new technologies have erased, they're ahead of the law, first of all, and they've erased these silos, the lines between these silos that government created a long, long time ago before these technologies were invented, we probably do need to look at it. I think we probably ought to look at it from almost an antitrust perspective. So competition law, So in other words, is there a concentration of market power, and is there abuse of that market power? Those should be two fundamental questions before we address anything. You have to have a concentration of market power and abuse of that power, really, before the government should act.
Well, this is what your Chairman Janikowski said about the congressional announcement to update the 1996 Act. I fully support this congressional effort. A limited update of the Communications Act could lock in an effective broadband framework to promote investment and innovation, foster competition, and empower consumers. I commit all available FCC resources to assisting Congress in its consideration of how to improve and clarify our communications law.
Great. And I look forward to working with Congress as well. And there are going to be a lot of ideas discussed up there. And I know certainly consumer groups, industry, Congress, the FCC, anyone who's interested, they're all talking to key members of Congress right now. This year, there are very few legislative days left, and obviously some big issues such as the Gulf oil gusher and things like that. So Congress is preoccupied. But I look forward to working with Congress, and if we can modernize the law, to make it better for consumers, that would be terrific.
And finally, I want to get one more reaction to what Chairman Janikowski had to say in his opening remarks when he's talking about the third way of broadband reclassification. Third way is modeled on the highly successful deregulatory approach that the FCC has used for almost 20 years for mobile voice services, application of a small number of Title II provisions with broad and reliable forbearance from all other provisions.
Right. First of all, I have a tremendous amount of respect for Chairman Janikowski, and just so folks know back home that we agree on a bipartisan basis at the FCC, actually on a unanimous basis about 90% of the time. But this is one area of disagreement that we have. And one thing we do have in common, which is we all want an open internet that maximizes consumer freedom. It's a matter of how do you get there. You also want a robust internet where innovation is not stifled at any part of that internet, any part of that supply chain for consumers. I disagree that placing common carrier regulation design for the old Ma Bell monopoly of 1934 is deregulatory. And as a legal matter, again, not to bore the folks at home, but Title II, he's talking about sections 201 and 202 in particular. That's the heart of Title II. And that specifically regulates rates, terms, and conditions of services. So are we now talking about rate regulation of broadband? And that's the whole rates, terms, and conditions. That's pretty much everything. That's all the authority you need to do anything you want. And so let's say it is limited to, let's take him at his word, which I do, that he is for a limited Title II regulation somehow. This causes a number of problems. But having 201, 202 there, and even just planting the seed of Title II into broadband, future commissions could regulate more if this were to be upheld in court, which I don't think it will. And I don't think it will because in order to do what he is proposing, the commissioner would have to say, what we did before was wrong. Something has changed in the marketplace. An administrative agency can change its mind if there's a change in fact that justifies more regulation in this case, or a change in law like new legislation, or a court mandate saying you've got to do this, you've got to regulate more. Okay, but what we have going forward is no evidence that would support that, and a commission that's about to say, on the one hand, broadband internet access is just like monopoly phone service from 1934, but on the other hand, it's so different that we're going to forbear, we're going to withhold from applying 42 out of 48 sections of Title II. So it's really incredibly different from that monopoly phone service. So much so that we're not going to apply the vast majority of the Title II provisions. Well, that's just going to look arbitrary and capricious, I think, to a court. That's the legal standard for overturning something that a commission does. So it's just the same enough to cross that threshold, to make that giant leap to say we're going to regulate it under Title II. But it's so different to where we're actually not going to apply most of Title II. I think that's really problematic on appeal.
So, Commissioner McDowell, how do you see this public comment period now playing out, and how long will this notice of inquiry situation play out?
So comments are due, the first round of comments are due July 15th, and I think replies are due mid-August, so it's a very tight turnaround. There's not a lot of time for folks to do economic studies, to file with us, or legal analyses, or gather the facts to give it us. That's a very short period of time. Here we are mid-June, and we're talking less than a month from now. The first round of comments are due, and July 4th, holidays in between. So it's going to be a quick turnaround. I have been told that the original contemplation was for some sort of order, set of rules to come out of the commission sometime this fall. I don't know if that would be before the election or after the election, but that would be a very tight turnaround.
Tony Rohn.
I wonder if we can pivot a little bit away from the conversation about Janikowski and Waste Board regarding broadband and talk a little about some of the other issues at the FCC that, this week have just, for whatever reason, seemed to fall to the political background. But
we have a lot going on.
And one of those big issues is the merger between Comcast and NBC. And I'm wondering if you could speak a little bit about that, what you see right now and where you see the issue going.
Yeah, I hate to tell you this, but I have a internal policy where I don't talk about either prospective mergers or merger approvals that are before us. I'm happy to talk about issues in general that you think could be related, but
one of the things that we saw this week, for instance, was that a number of groups had asked for an extension in the public comment period, the first leg of it, because they felt that the content that Comcast and NBC had filed wasn't in a format that was amenable to studying it and producing some kind of response very, very quickly. The FCC ultimately denied the first of those filed by Bloomberg. I'm just wondering, do you think that there's more time that's needed on this to just kind of study it, or are you happy with the way that the proceeding is going?
Well, certainly a lot of information is coming in, and we look at it concurrent with the Department of Justice, and sometimes it's the Federal Trade Commission, but not in this case. So there'll be a very thorough review. I want to make sure, just in general, that mergers are looked at and resolved one way or the other, approved or not, in as tight a time frame as possible. A lot of the companies that come to us with these merger applications have financing deadlines. Banks will only lend the money up to a certain point, and it can cost millions of dollars a day in the interim. So as a matter of good government, I would like for the FCC to try to resolve it as quickly as it possibly can. We have a new merger team, our transaction team, a new head of it who's come in. And perhaps that will help facilitate things. But it should be thorough. We want to make sure we get it right, but as quickly as we can at the same time.
And we are out of time, so we're going to have to save those other issues for another visit. Commissioner Robert McDowell, FCC, thank you for being on the Communicators again, as always. Tony Rahm, Politico, thank you.
Well done.